about the topic. Abhishri, over to you.
Thank you, Fawzia ma'am, for the wonderful introduction about the forum. Hi, everybody. Good evening. I am Abhishri, and today's discussion for the evening is feminist lawyering from invisible to invincible. As the
Feminism is cancer.
As the challenges in this profession increases by each passing day, this topic has immense importance because it requires a thorough analysis of what it actually means to be a lawyer. Feminist lawyering is an effective mechanism by which diverse perspectives and opinions of all the female members of the bars can actually
Feminism
be
is cancer.
in order to formulate gender-neutral laws. The subordinate status of women has been prevalent in the society since time immemorial. However, the commitment of various women who have challenged this subordination and then to have brought major changes in the system is something which remains an inspiration for all of us. Since social reforms is an important part of feminist lawyering, hence the challenges remain consistent and strong perspectives are still required within the system in order to change the woman's status through a rework of law and its approach to gender. Without any further delay, we would like to introduce our speakers for the evening who have dedicated on specific issues concerning women and human rights and their challenges that are prevalent in time. Over to you, Fawzia ma'am.
Mrinalini, there's somebody who seems to be disrupting the proceeding intentionally. Please remove them and note their name. I'm going to make a complaint, a police complaint for this person.
Nitya, someone has hacked the system.
Yes.
And he's repeatedly saying communism is cancer.
Feminism. Yeah, feminism.
Can you ask your systems person to remove this?
Mrinalini, can we do something about this? This person needs to be removed. If we can pause and let's take down the details. I'm going to make a police complaint because in one of our earlier sessions also, in another LiveLaw session also, this type of a mischievous element had entered. So I think we should make a police complaint against this person.
Ma'am, may I suggest a way out?
Yes.
Throw these people out and then lock the meeting. Others can
use
YouTube.
No, don't lock the meeting because there are a lot of college students and all who will be entering. But you please throw these people out and note down their names because I'm going to make a police complaint. And everybody who is going to make any mischief remarks, please be warned.
I'll keep throwing them out. I am so sorry to the panel.
I apologize for this interruption. And I sincerely believe we have a stronger reason to talk about feminist lawyering today.
Vinod calling from Live. I'm Vinod from LiveLaw. Can you please make me the co-host as well? I will just try to weed out all these people who are trying to...
Yes, please make Vinod this thing. And I think in a way, our group has really become a threat to a lot of people. So these type of, interveners are coming. This is a very unpleasant thing.
Absolutely.
We are doing that from the other end, but please continue. Let's not let them get the better of us.
Right. So as I already said, that we have a stronger reason to talk about feminist lawyering today, and we have a stronger reason to do many more webinars through this wonderful platform, where it is actually becoming very, very vibrant and very, very right. So coming back to the introduction for one of our most awesome speaker today for the day, and we've been waiting to hear her. She's been with us despite the fact that she's a little unwell since yesterday. So I first of all thank Indira ma'am to be here with us. So our first speaker, as you know, is Miss Indira Jaising, who definitely needs no introduction. Indira ma'am was the first woman designated senior advocate by the Honorable High Court of Bombay. And also received one of the most prestigious civilian awards, Padma Shri in the year 2005 for distinguished public service. Indira ma'am has come a long way and recognized nationwide as a lawyer and a person of substance. Elegance personified. Her very name means beauty and splendor. She is just not a story. She is a book which should be read and reread by every student of the law. Whether it was the aggrieved victims of the Bhopal gas tragedy running from pillar to post for their due claims from the American corporate called Union Carbide, or the helpless pavement dwellers who were being evicted from their living space in Mumbai, or a woman fighting for property rights in an archaic patriarchal system, Indira ma'am always took the bull by the horns, fighting tooth and nail for justice for the most oppressed and most deserving. Bold, courageous, robust, while taking stands against the hegemony of the powerful, her cases ultimately made a powerful contribution to the development of constitutional jurisprudence in India. Jaising, I'm sorry, I went on the mute, I guess. The journey tracing makes it clear that her primary focus was on the human rights issues, more specifically the rights of women. She represented the air hostesses of Air India in their quest for equality for law. Since 1990, she has been practicing in the Supreme Court of India. She has had a very long and abiding interest in the accountability of the judiciary. She argued the Mary Royce case, which led to the grant of equal inheritance.
Nitya aunty तो गाड़ी में बैठी हुई है.
The question of equal guardianship rights for women in the Geeta Hariharan case. In 2009, she became the first woman to be appointed as Additional Solicitor General of India and was named 20th in the list of 50 greatest leaders of the world by the Fortune magazine, because of her relentless endeavor as a champion for humanitarian causes. Her name was also featured in the India's first pictorial coffee table book, India's Most Powerful Women. She is also well known for having co-founded the Lawyers Collective in 1981 and contributes to be a trustee to this day. She also founded the legal news web portal, The Leaflet, in the
Who
year
was funding
2018.
Lawyers Collective from abroad?
Her strong
Who was
commitment
funding
and
Lawyers
depth of women
Collective from abroad?
representation is clear from the innumerable
Foreign funding
cases
of Lawyers
which Ms.
Collective.
Jaising
Who
has
was funding
dealt
them?
with. Few of the many cases pertaining to issues concerning women's rights makes it abundantly clear that her prerogative has always been to promote women's rights. She successfully argued for the rights of women to enter the Sabrimala temple. She also represented Bindu, a Dalit woman who became the first to enter the temple in
ये सुन बे तो
2000.
नहीं था.
She also represented the Buyback Collective in the Saira Bano case, which challenged the concept of triple talaq. She also represented woman additional district judge who was sexually harassed within the judiciary. Ma'am, you have been indeed an inspiration to us with your contribution, along with the many women working on social reforms in the independence movement who made human rights for a woman a reality. Your strong belief that law is an instrument of social change is indeed an inspiration to one and many, and to have been a part of such social change. Anyone who knows her work can share the opinion of the Fortune editors who stated, when the poorest in India needs a voice, they find one in Jaising, a lawyer who has dedicated her life to battling injustice. I would now ask my co-moderator Abhishri to introduce the second speaker for the evening.
Oh yeah. Oh yeah. तेरा bomb figure.
Thank you so much, Fawzia ma'am. Nitya Ramakrishnan, our second speaker for the day, is a well-known senior lawyer practicing in New Delhi with emphasis on criminal law for over 3 decades. As her name symbolizes consistency and everlastingness, her commendable work in the field of human rights and women's rights will remain ingrained in our minds and books forever. She is renowned for her trial defenses in cases such as the Parliament attack case and the Haran Pandya murder case. In the field of criminal defense, she holds tremendous reputation and is also recognized for her work by challenging the censorship imposed on various political documentaries, such as the Bhopal Beyond Genocide and Punjab from Behind the Barricades. With a specialization in national security legislation, she has appeared in a variety of cases of public importance. She has conducted the defense in many important terror trials. She has authored numerous articles on various aspects of criminal and constitutional law. She has also been a guest faculty at eminent academical institutions such as the National School of Law, India University, Bangalore, Jamia Millia Islamia, New Delhi, and the School of Convergence, New Delhi. Her strong persona and understanding of the justice system can be traced back to the book authored by her, Custody, Law, Impunity, and Prisoner Abuse in South Asia, which strongly deals with the politics involved in custodial abuse and the justice system prevalent within India. She is also known to be the person who has paved way for a more vocal society which can be open about various political hypocrisies existing within the criminal justice system, which include issues and concern in relation to custodial abuse, wrongful detention, and the procedural errors existing in the criminal justice system. The credibility of evidence and the deficiency in rendering the criminal justice system was well articulated by ma'am while she was the counsel representing one of the 5 human rights activists who were arrested in the year 2018. She had actually beautifully explained the discrepancies in the credibility of evidence and the sequence of events leading to the arrest of the 5 human rights activists. Having been involved in such distinguished and notable cases, ma'am, you're indeed an excellent illustration of being invincible. I would like to welcome Nitya ma'am with one of her own quotes, which is supremely enlightening and is also very, very relevant at the present time. Plurality of opinion is a bedmark of democracy. Ma'am, we are eagerly waiting for your perspective and opinion on this. We would also like to inform the audience today that Nitya ma'am currently has a family member in the ICU and would probably have to get away in case the situation changes during the session. However, ma'am, thank you so much for joining us for the webinar today on our platform. Over to you, Indira ma'am.
Before I begin, can I just request your technical team to try and take care of hackers, because we are discussing a very serious subject here, and it would be nice if everybody could hear it without any interruptions. So if one of you could just talk to your technical team. There is an obvious conscious attempt to sabotage this webinar. I guess it should be, we should take it as a compliment, as a sign that we matter. But nevertheless, I'd like to be heard by those who have taken the trouble to log in. So please do make that effort and ask your technical team. It is possible to throw out hackers, and if somebody can just do it, it'd be very nice.
They can actually block them.
I think they've kicked out. It was a thing called Sensex Chambers, and some other person who deliberately joined with a fake name. So I think now, ma'am, they've been kicked out, and we are really sorry about this. And I would suggest that close the entry. Unfortunately, there are a lot of people wanting to enter, but they can hear it on live stream.
Yes.
Okay, great, Mrinalini. Thank God. I think now that mischief maker has been kicked out, and I'm registering a complaint. Sorry to both the speakers.
Thank you very much.
Yeah. So before ma'am starts, and before we are enlightened, I just want to say a nice couplet for her, and to enlighten the mood of the audience here. Why bazm mein itna to mir ne dekha? Why bazm mein itna to mir ne dekha? Par uske baad chiragon mein roshni na rahi. Indira ma'am, please. This one.
Thank you. Let me begin by thanking you for that more than generous introduction. I also wish to thank all those of you who are online to take time out from 2 very dramatic events today. One, the announcement of the results of the American presidential race, and the other, the case in the Bombay High Court relating to Arnab Goswami, which has attracted equal amount of attention. So thank you for diverting your attention from two really interesting issues to this webinar. And as I said, it speaks a lot for the popularity of your webinar and of course the subject of which we are very proud. Now, I'd like to begin by saying that I need to really explain what I mean by feminist lawyering. You should understand very clearly, by feminist lawyering, I don't mean espousing the cause of women alone. I also don't mean that I'm into feminist lawyering because I'm a woman. We need to distinguish between the concept of sex and the concept of feminism and the ideology of feminism, which can reside even in men. I recall that Justice Sikri, on his retirement, spontaneously made a statement while addressing the bar in the presence of the then Chief Justice of India, I am a feminist. And, many of us were completely taken aback, but then we recalled his judgment in the Nalsa case, and back came the chorus, yes, you are a feminist. So let's understand that feminism and your biological sex are not to be conflated with each other. So where am I coming from? Where have I come from? I would like to begin by telling you that I consider myself as one of what Salman Rushdie called Midnight's children. In that sense, I'm very different from many of you on this webinar today. You're probably 2 generations younger to me, but I'm proud that I carry with me the legacy of the ideas of the freedom movement of this country. I was born and brought up on those ideas, and they will stay with me. They have stayed with me till today. They will stay with me till the day I die. So I say I'm a lucky person. And so what was this freedom movement all about? It was about an amalgamation of 2 parallel movements. The first being a struggle for independence from British rule, and the second being a struggle for social reform. I'd like to quote from a judgment of Justice D.Y. Chandrachud, where he explains this, and this is a quote. Besides, he calls it the other side of independence. Besides the struggle for independence from British rule, there was another struggle going on since centuries and which still continues. That struggle has been for social emancipation. It has been the struggle for the replacement of an unequal social order. It has been a fight for undoing historical injustices and for righting fundamental wrongs with fundamental rights. The Constitution of India is the end product of both these struggles, unquote. So this is where I am coming from. I am coming from the other side of the independence movement. And so, although I was not an active participant in the anti-imperialist struggle, I have been a very active participant in the other side of independence, that is the struggle for social reform, which goes on till this day and which will go on after me. And many of you will continue that struggle. I have no doubt about that. That being said, I would like to remind you of a quote from and that, by the way, will explain to you something that Fawzia pointed to. How is it that I can span issues from the rights of the homeless, the pavement dwellers, to the rights of the hawkers, to the rights of women, to issues of impunity, to the most recent case which I'm presently arguing, that is the case of Varavara Rao, Dr. Varavara Rao, who's bedridden and is being denied the right to health, where the argument is prisoners are not denuded of their fundamental rights in prison. So if you look at the span of these issues, they cover social, political, economic, and cultural rights. And what I would like to share with you is my understanding that these rights are indivisible. You cannot work on political rights without working on social rights. You can't work on social rights without working on political rights. You can't work on political rights without working on economic rights. And you can't work on economic rights without working on cultural rights. And therefore, you as a person are indivisible. You as a lawyer are indivisible. You as a feminist are indivisible. And that's where a lot of my lawyering has come from. Now, that being said, the Constitution of India, of course, is a document which directly answers to the call for equality. Equality for women, equality for Dalits, equality for Adivasis, and equality for many other subaltern groups. I do not subscribe to points of view which argue that that there is no merit in bourgeois democracy. I think bourgeois democracy, yes, it's bourgeois democracy, but it is still a form of democracy which we treasure. And this is what explains my enthusiasm, which I go to court. I never go to court feeling that I'm going to lose my case. I always go to court with the feeling this is a case I'm going to win. Why? Because I believe in my own arguments, because I believe in the Constitution of India, and because all my arguments are anchored within the Constitution of India. Now, the question then becomes, what really is equality? Is it what Anatole France said, that the pavement dweller and Mukesh Ambani both are equally entitled to sleep below a flyover in the city of Mumbai? No, obviously not. And to deal with this issue, we have evolved, feminist theorists, in particular Catherine McKinnon, evolved the doctrine of substantive equality. Now, I believe that the Supreme Court of India has not resolved this question for itself. They have not given us a definitive answer of what is the meaning of equality. They are confused. Our judges are confused. And many of them don't know where to go from there. But in a recent judgment of the Supreme Court, once again, I'm compelled to quote Justice D.Y. Chandrachud, who explained in a matter relating to reservation, the issue has always been, is reservation an exception to the rule of equality, or does it further equality? And this is what he said. For equality to be truly effective or substantive, the principle must recognize existing equalities. There you go. Recognize existing equalities in society to overcome them. But if you're in denial, if you say no, Indira, Jaising, and a pavement dweller all are equal, you will never reach your goal of justice for all and equality for all. I must say, this became very painfully clear to me during COVID. I ask you this question. Can we honestly put our hands on our heart and say that a poor person and a rich person both have equal access to medication during COVID? No. In a situation in which services are limited, who do they go to? They go to the rich and the powerful. So it's false to suggest that we are a society who have attained to equality. We have not attained to equality. So Justice Chandrachud reminds us of this, acknowledge and admit that there are existing inequalities of opportunity in society, and then use affirmative action to overcome those equalities. Now, I'm going to quickly jump. I know our time is limited, and I know we have other speakers and we have Q&A. I'd like to just quickly give you one example of what I consider to be a high watermark of my own feminist lawyering, and that is the Sabrimala case that I argued. It was a very difficult case to argue. It sits at the intersection of religion and equality for women. A very, very, very difficult intersection to marry together. Some would argue that these two rights are mutually exclusive because all religions do discriminate against women. But I took to the challenge and I said, let me see how I can deal with this. And I must tell you, here again, feminist lawyering means you make the personal political. And I drew on my own personal experience. I, as a teenager, when I began to menstruate, I saw my own mother being put out as an outcast, not being allowed to enter the kitchen, not being allowed to enter the temple of the house, and her food used to be brought to her. This happens in a lot of upper caste Indian households who have not been exposed to any form of progressive ideology. And I've seen that. I've seen my mother undergo that humiliation. And suddenly the penny clicked in my mind. I said to myself, this is what being untouchable is all about. Literally, you could not touch a menstruating woman because she was considered polluted, she was considered unpure. And it goes back to Manusmriti, where Dalits, animals, and women were all considered polluted. Society fears the reproductive potential of women. And there is only one way to keep them in check, and that is to ensure that they marry endogenously within their own caste and do not cross these limits. So I made bold to argue that the rule of the Shabrimala temple, which said that women between the ages of 10 to 50 cannot enter the temple, was a form of untouchability, apart from being blatantly discriminatory based on sex. Now, here's a bit of humor in court. What was the argument in court? They argued that this discrimination is not based on sex, it's based on age. It's between the age of 10 to 50 that you cannot enter. So I had to get up in court and with a laugh ask them, oh yes, but what happens to women between that age of 10 to 50? Do you know? Can you answer that question? And do you know what the male lawyer said? I'm not going to name the male lawyer. I'm going to leave you to guess who it could be. Said, my lord, you know, that thing which happens to women. Male lawyers in the courtroom could not get the word menstruation out of their mouth. Now, in a court of law, if you can't get the word menstruation out of your mouth, how are you going to argue for non-discrimination based on sex? So the argument was, this discrimination is not based on menstruation. It's not based on sex. It's based on age. I said, very well then, ageism is also a form of prohibited discrimination. But fortunately for us, we have a really history-making judgment where a bench presided over by the then Chief Justice held that women have an undisputed right to enter the Shabrimala temple. Now, these are some of the ways. It's far too detailed a discussion for me to do in 20 minutes, but for those of you who would like to continue this discussion, I'd definitely be available. I've written about it. The article has been published in a publication of the Indian Bar Association under the title of Feminist Lawyering, and I'd be very happy to receive your feedback from that. But it's what I call the ghost of Narasu Appu. Now, Narasu Appu was a judgment delivered way back in 1950s by the Bombay High Court, where they said constitutional rights do not apply to personal and family laws. I ask you a question. If personal law does not apply to family law, would you not agree that about 90% of the life of women are out of the framework of constitutional justice? I think so. And this is the reason why I've said the ghost of Narasu Appu is stalking the Supreme Court of India. And it is that ghost that has to be exorcised by admitting that many of our laws relating to marriage, relating to divorce, relating to alimony, relating to child custody, relating to guardianship, relating to adoption are discriminatory against women. A small step was made in that direction in the Saira Banu case, where Justice Nariman, of all the 5 judges, this lone judge who held that the triple talaq was manifestly arbitrary. Again, I will not get into the details of the argument because it's very complex. It's here that the intersection of religion and the right to equality needs to be sliced through. And I did come up with an argument which enabled us to slice through it. And I'm proud of that judgment, though it doesn't exactly say what I would want it to say. Now, So for me, my constitutional journey in the field of feminist lawyering has been the process of delinking the religious from the secular. I believe that our country is facing a major threat to secularism today at many different levels, at a political level, at a constitutional level, at a social level, at an economic level, at the level of abuse of the criminal justice system, where provisions in statutory laws such as sedition and the UAPA are used against minorities and also used to curb dissent. So the challenges for your feminist lawyering are so multiple that it is not possible to deal with them in one webinar. But I think this separation of the domain of the religious from the secular is really hitting the nail on the head when it comes to equality for women. I will quickly move on to the issue of representation of women in positions of power. There have been, as we all know, only 7 women judges in the Supreme Court over the last 70 years. I wonder whether that 70 and 7 are linked. I wonder whether that figure of 7 is ever going to be crossed. I don't know. But once again, I wish to make it clear, the mere fact of your being a woman judge doesn't make you a feminist. And therefore, I need to justify why I still argue for increasing the number of women in positions of power. I think having equality of representation in positions of power is a goal in and of itself. Diversity of representation on constitutional institutions, be it the courts, be it the executive, be it the legislature, be it autonomous institutions like reserve banks or the election commission, etc., has to exist. Why does it have to exist? Let me give you an answer to this question, again from my personal experience. I was arguing the case of Rupan Bajaj in the Supreme Court on one occasion, and the matter was listed before 2 male judges. She turned around and she asked me the question, Ms. Jaising, when it comes to the rest of the world, the Supreme Court says in the Vishaka judgment that there must always be a woman as a chair of the committee. How come the Supreme Court doesn't apply this logic to itself? Why is my case being heard by a bench of 2 judges and who are both male? And my answer to her was, my dear Rupan, there is no woman judge on the Supreme Court today. Where can I manufacture a woman judge for your case? So let's just get on with the case and conclude our arguments. Now, this logic applies equally to the absence of SC judges, ST judges. And now I would argue the LGBT communities to be represented on the bench of the Supreme Court, and all high courts, and of course, all trial courts as well. So representation is a goal in and of itself to enable the litigants to identify with the people who are responsible for making decisions about their lives. And this is not to say that they will always decide in favor of the person. No, they will base their judgments on the concept of justice, but the litigant will go away with the feeling that his community has participated, his or her community has participated in the decision making. I'd like to conclude by coming to issues which I consider very, very, very important, and that is infrastructure issues. It is my claim that courts, including the Supreme Court of India, were designed, the architecture of the courts is sexist. It was not designed with the vision that one day these courts would be flooded by women lawyers. I will proceed to give you a couple of examples. Up until 2 years ago, there was no creche in the Supreme Court of India. Once again, this came home to me when I was ASG. One of my juniors had a little child who was 1 year old. And when she would come to work to me in my chamber, she would leave that child with her maid in the middle of summer on the lawns of the Supreme Court. And one day when I was passing by and I saw this, I said, this is not working for me. I have to file a petition in court asking the court to set up a creche. And I did it. Today, if any of you have had occasion to enter the Supreme Court of India, you will see a state-of-the-art creche in existence in the Supreme Court of India. Countless women have thanked me for this, and of course, thanked the Supreme Court. And I know women who told me, Madam, when we were practicing law, there was no such facility. And we were beset by guilt about leaving our children at home and going to work. And I said, no woman should be compelled to choose between motherhood and her right to practice law. So we got that creche. Another example of hierarchy, dismantling hierarchy, was the petition which I filed asking for objective guidelines to be set out for the appointment of senior counsel. And a third example of an infrastructural issue that I raised is the issue of live streaming of Supreme Court proceedings. I filed all these petitions in my own name. I said I have the locus because I'm deeply concerned about the administration of justice, and I want live streaming of Supreme Court proceedings because not everybody can enter the courtroom, and you can't say this is public justice till you throw the doors of the Supreme Court open to the general public. I think I'm going to stop here to give other people, including Nitya, an opportunity to reflect on these issues. But I can't resist from telling you a very, very small incident, which words that I uttered without even thinking what I was saying. I was in courtroom number 1 and arguing a very, very important case before the then Chief Justice of India. And I found a degree of insensitivity towards the issue. And suddenly I looked above the head of the judge, and I found it said over there on the logo of the Supreme Court, Yatho Dharme Tatho Jayate. It's unlike the logo in the high courts, which is Satyameva Jayate. The two are different from each other. Now, I'll tell you some other time why this difference, but I looked at the judge and I said, you know what, my lord, there is a tragedy here. And the tragedy is that we lawyers enter the courtroom through the front door. And the first thing that I see when I enter the courtroom is that crest above your head. I don't even see you. But your tragedy is you enter the courtroom from the back door and you're unable to see what is above your head. So if you don't mind, I give you a small suggestion. Before you are seated on your chair, look above you, what's written on your head, and then proceed to do justice. Thank you for this opportunity, for saying a few words to you about how I view feminist lawyering.
Thank you so much, Indira ma'am, for such a wonderful session. And I'm sure everybody has a very, very nice insight after listening to you. We would now like to welcome Nitya ma'am. So Nitya ma'am, with you and for all those that you have also worked for and the long way that you've come, so this one is for you. उनके आने से जो आ जाती है चेहरे पे रौनक, उनके आने से जो आ जाती है चेहरे पे रौनक, वो समझते हैं बीमार का हाल अच्छा है. Nitya ma'am, please.
Ma'am, you'll have to unmute yourself.
Yeah, Nitya ma'am, please unmute yourself. I'll just call it.
Unmute. Yeah. I said thank you for this poetic welcome. Makes me feel very good. Thank you also for that flattering, if exaggerated, introduction. Thank you, Indu, for that riveting talk. It's a great privilege for me to be on the same panel as Indira Jaising, for whom I have great respect and greater affection. Women have held up the sky ever since recorded history. The discovery of agriculture, the maintenance of the ecological balance, the setting up of social and institutional units, the making and breaking of empires, the history of civilization can be seen as the history or as the charting of the indomitable feminine spirit. I say this because this spirit was displayed at a time when feminist discourse was not there in the sense in which we understand it today. Notions of equality or justice were not there in the sense in which we talk about or aspire to today. Nevertheless, in the face of patriarchy, in the face of patriarchal definitions and constrictions, in fact, in the face of a deliberate demeaning of the feminine, this spirit has been maintained so that today we talk of feminist discourse. So invincibility to me is that spirit in the face of utmost adversity which patriarchy has imposed on the women. And when we speak of being invincible, we speak of that spirit to which all of us are heir today, as women, as lawyers, as persons. This introduction in my speech is not necessarily rhetoric. I think it has a bearing on two aspects which relate to today's topic. One is that being heir to this incredible spirit which has led to a feminist consciousness articulated as it is today, there is something we owe to it. There is something that we must redeem. And a spirit which was displayed, as I said, at a time when this nature of feminist discourse was not prevalent. We should realize that even today, there are multiple pockets of reality, even within this country and certainly without, where feminist discourse, as we understand it, or even otherwise, where the notion of equality and the notion of justice is very far away. So invisibility for me is the invisibility of this reality. The fact that hundreds of thousands of women live a life of unwaged labor, live a life of utter drudgery without being recognized for their labor. Several of them walk miles and miles on hilly terrain just to fetch a bucket of water or fetch firewood. There are women who work their finger to the bone, pour themselves into labor, and their children grow up on the wayside. Indu referred to some aspects of this in her lawyering, which she dealt with. I'm talking about the broader social reality. That there are women with a touching faith in our law and law enforcement agencies, victims of rape in Chhattisgarh, victims of security forces, of vigilante forces like the Salva Judum, of the special police officers, walk miles and miles of forest land, either carrying their babies or actually leaving their babies under bushes because they want to file a complaint, and they encounter a police station surrounded by a barbed wire. Nandini Sundar and I raised this before the Verma Committee. So people who want to access justice are unable to access justice. This is invisibility, not in the sense that this reality is not known or has not been written about. This is invisibility in the sense that this reality does not impact our social conscience, our political conscience, or our judicial or our institutional conscience enough. Feminist lawyering, to me, first and foremost, as the redemption of that spirit of invincibility to which we are heir, must foreground this social reality, which is completely devoid of any redress. So while invisibility or visibility may have to do with the position of women in power, and while I agree with Indira that It does not necessarily mean that there is a linear progression towards what we may consider feminist conscience. It is certainly indicative of a breakdown of stereotypes. It is a change in the face of the power structure, to have women, to have Dalits, to have others. That is an important way of breaking down the stereotypes and therefore relevant to social reform. But yet that is not the only invisibility. As interlocutors, as crusaders for justice, if I might paraphrase Edward Said, he said this in a different context, in the context of human rights, I think feminist lawyering is to reveal what the dominant power has hidden, to render pronounceable that which the dominant power has silenced or declared unpronounceable. So having said that, I would definitely, as I said, that the visibility of women in positions of power in judicial office as lawyers, it has increased. In my own career, I have seen very, very many more women, more prominent, occupying positions within the judiciary and elsewhere. It is, as I said, an important check on. Can you hear me? Can you hear me?
Ma'am, very clearly.
Okay,
very
fine.
clearly, ma'am. Very
Fine.
clearly.
It is a check, but and that is a dwindling of invisibility, in a sense. There is also a dwindling. There is also conceptually a greater visibility to feminist discourse. It may not be as much as we wish for it, but some 20, 30 years ago, the grounds on which a woman would be considered to have acted cruelly in a matrimonial cause, like not conforming to, not catering enough to the in-laws, not cooking at home, what was considered cruelty, I don't think it would be viewed in the same manner today. And even if there is space for us to interrogate that stereotype, which may not even have occurred to legal strategists as much as it does today. In matters of maintenance or rights to property or right to custody, I agree with Indu that there is so much that has to be overhauled. But I'm saying in terms of discourse, these notions have entered the discourse that merely because a woman makes a home and does not earn, it is not as though she's entitled to less, or it is not as though she's therefore incapable of caring for the children. So the notion of her contribution, this has all entered the discourse. And therefore, it is significant of a certain change in mindset. Too little, perhaps, much more needs to be done. Feminist lawyering, I agree with, it does not have to be a woman, but with keeping this in mind. Also, there is an aspect of plurality to which I will come in the end. And it does not have to be a woman, but it has to be an ideology which interrogates patriarchy. It has to be an ideology which interrogates limiting stereotypes. And that interrogation is not a monolithical, unidimensional interrogation, but to that I will come towards the end if there is time. Having said this, and having seen some of these changes, no doubt due to pioneering lawyers like Indira and others in other fields, misogyny is deep and widely prevalent in the social media, as we saw, just as we began today, and elsewhere. The easiest abused words are those involving women and their anatomies. It proliferates. It is there in institutions. It is there when the best of us refer to our daughters as liabilities. It is there when in quarters where the law is expected to be upheld, there are allegations of sexual harassment and not enough interrogation into it, not enough of an inquiry into it, not an open, it is not open to bring the truth to book, whoever is guilty or not. So misogyny is prevalent everywhere. Still, and one challenge for feminist lawyering is to have to deal with this. It cannot always be dealt with in courtrooms. It'll have to be dealt with attitudinally. It's a negotiated space. Does the attitude come first or the norm? It's not an easy answer. It's a negotiated space, and feminist lawyering will have to contend with differing views and strategies to deal with this. It has impacted criminal law also. As I said, the stereotypes of women in terms of matrimonial litigation and allied litigation. For instance, notion of the unhinged woman, the insane woman, the depressive woman who has taken her own life, the constructs of it. For instance, one of the best cases in criminal law, Sharad Birdich and Sharda, one of the most, it's almost a locus classical on circumstantial evidence, on the role of the court under section 313 of the CRPC. But in the facts of that case, where two courts had held the husband guilty of murder, by a strange twisting of facts and a construct of the insane woman, the perennially depressive woman, that conviction was overturned. Overturning of conviction on circumstantial evidence is one thing, but the construct of the unhinged woman, the hysterical woman, these are concepts which today our discourse is questioning. I'm not saying it is displaced. So those are two ways in which lawyering directly affects visibility and invisibility. But as I said, the most important challenge in terms of visibility, invisibility, and invincibility is for us to make visible and foreground and important the issues of those women who are unable to access justice, either socially or they're not able to garner the attention of the power structures. And as lawyers, I think that is a very important, that's one of the most important choices for us. So we have to, in that sense, look beyond ourselves and our careers. For whom, what is it that we are articulating? Having said that, perhaps I'm entering into slightly controversial territory. Because, you see, there is a certain limited space in public imagination. Law is a site where conflicting worldviews are clashing. Conflicting feminist worldviews are also clashing. So in that clash, there may be a tendency to raise issues which then push into the background more compelling issues, starker issues. They may all be feminist issues in a sense of speaking. Now, this is not to say really that all of these issues are not important. Some notions of sexual harassment, that every allegation of sexual harassment is equivalent to a gang rape. Maybe one, it's the view of radical feminists. There can be more than one view of feminism. But the point I make is not that such issues should not be raised, but to be cognizant of the fact that in raising these issues, there may be a pushing back for others who are already not getting any attention. The idea is not that such issues should not be raised, but it is to be cognizant of the fact that patriarchy is not a thing in itself. It's not a man versus woman issue. Patriarchy comes linked with issues of ethnicity, race, class, the urban-rural divide. There are many other aspects of social reality which enter the notion, which enter patriarchy, which may exist independently of this, which brings me to the most important point, I think, is that feminism is not a unidimensional theory applicable to every fact situation. Feminism is a state of interrogation. It's a state of inquiry. It's a philosophical state of mind where various worldviews may enter and they may debate with each other. In India itself, we have seen, for instance, reservation for women. There's a view that 33% reservation is important everywhere, right from the panchayats to parliament. And the other Indian feminists have questioned this. Now, this, although I think the Delhi High Court, your forum must perhaps choose some of these issues for feminists to debate. Today is not the time to say this is right or that is right. In fact, on many of these things, I often feel much can be said on both sides. But the important thing is that feminism and therefore feminist lawyering is enriched by debate and disagreement. It is not a straitjacket. To view feminism of the notion of the feminist lawyer in a particular manner, or to straitjacket it would be the typical male narrow-minded view of a feminist, completely ill-informed. Or, for instance, on freedom of expression. There are at least two views amongst feminists. One is that anything, either pornography or anything that depicts women in a explicitly sexual fashion is anti-women and must be banned. And there is another view that speaking against freedom of expression is not necessarily a feminist viewpoint. This was also the debate between Betty Friedan on the one hand and Catherine McKinnon and others on the other, as far as I remember, the Feminine Mystique, when she wrote. Now, it is an enriching aspect of feminist thought, which is you have tried to or broken the shackles of patriarchy. You don't really have to kowtow to a particular notion of feminism. And that is really the most liberating aspect of feminism and therefore feminist lawyering, as I can see. Or, for instance, even in the notion of Me Too, Margaret Atwood has a view, which is different. And these are enriching and engaging issues for feminist lawyering, whether they happen to be female feminists or men with a consciousness or a cognition of this way of thinking. It doesn't matter. The gender doesn't matter. I agree with Indira. But the thought process and the clashing and the negotiation. Radical feminists believe in carceral feminism of a nature. They believe that the state must enter to remedy the imbalance. Even on the notion of criminal law amendment or on the notion of marital rape, there may be more than one view. And the other view is not necessarily anti-women. Where to locate feminism within human rights? Is feminism human rights? Is feminism a feminist view of human rights? Is there a patriarchal view of human rights? I mean, I don't have answers to this. There are no easy answers to this. But I would say that it's a celebration of the spirit of feminism. It's a celebration of the spirit of liberation. It's a celebration of spirit simplicity. And celebration of spirit is, in my view, invincibility. It is that spirit that I salute, and it is that spirit that I celebrate, and it is that spirit that I would like feminist lawyering to represent. Thank you. Have I kept the time?
Yes.
Very well.
Ma'am, thank you so much. Thank you so much for the wonderful session from your end on this topic.
If it was not wonderful also, you're not going to say it's not wonderful, no?
No, ma'am, it was indeed inspiring, and it actually answered a lot of our questions when we began with the session. When we began with the session, we actually had a lot of questions, and ma'am, it has actually answered a lot of them. So I'm sure a lot in the audience, including myself and Fawzia ma'am, have a lot more for both of you.
So yes.
I'm sorry, I can't do anything more about the light. I'm sorry about that. You know, I'm in the hospital parking lot and can't do anything more about it. I'm sorry. You want me to hold a torch or something? I'm sorry about this.
Ma'am, it's fine. We can hear you. And it's so grateful that, despite the circumstances, you came, and it's really been so interesting. I mean, I have enjoyed both the speeches so much. I'm sure.
And I think it's today the light and the voice which is doing the magic here. Both the things. So now that, like Abhishi said, that we had so many questions when we chose this topic, and we chose the two of you as our speakers, as our honorable speakers. We had so many questions in our mind. After listening to the two of you, of course, there is a lot of questions which have been answered in your talk itself before even we asked. But there's a list of questions I see here in the chat box, and there's a list of questions that we made, responsibly to ask at the end of the session. So with the permission of the two of you, I may now open the floor for the audience and for the question and answer rounds. जब सवाल होंगे तो जवाब भी मिलेंगे. Legal practitioners are architects of social change, and the topic today is directly linked with social reforms. Having said that, what, in your opinion, are the smaller transformations that as legal practitioners can do in order to transform and maintain gender neutrality? Any of you, would like to answer? Indira ma'am.
You want me to answer? Fauziya, can you hear me?
Yes, ma'am.
Okay. Yeah, I consider your question very, very important because at the end of the day, none of us individually can kind of make a revolution, so to say. But it's really those small, tiny little steps that I think add up to change. So I welcome your question. Now, for me, those tiny changes have come by not addressing judges in a sycophantic manner, by not, and at the same time being respectful. I have a very interesting way of expressing my approval and disapproval of judges. And when I approve of what a judge is saying or doing, I'm happy to call the male judge, my lord. But when I find that he is going off the rails, then just say a very stern sir. And I find that, my message is taken across. But the important issue is learn how to stand your ground and do not give up on an argument. Try your best to persuade the judge of your point of view. And of course, if you don't succeed, it's a different matter. But to give up before trying, which many women often do, is not right. So if you're talking about small changes, I can tell you that many of my juniors, some of them I think are actually on this program today, have told me that, Ms. Jaising, one of the best takeaways we ever got from you was just watching you holding your ground in a court of law. And that gives the confidence, because as a young lawyer, you often feel, oh, how can I address a judge? And what will the judge say? What will the judge think? But speaking your mind, speaking it in a respectful manner, is saying that you disagree with the judge, I think that's fabulous. It's one small way of making change. So you have to think of ways and means of dismantling hierarchies within your ecosystem. You may not, as I said, be able to make a revolution, but you can change your own ecosystem. You can influence your juniors. You can impact judges. I know many judges change their minds after listening to a good argument. So I could go on and on. There are many, many, many small ways in which you can have an impact. I would like to just say that I think all of us should keep our eyes and ears open when we interact with our colleagues, when we interact with judges. Be very observant. Be observant of small, tiny injustices happening against you. Is your junior being given the respect they deserve? Is your junior being acknowledged in the argument? Is anybody who worked on your case, are you acknowledging the people who assisted you on your case? I make it a point. When I end my argument, I always say, I thank you for a patient hearing, and I thank so-and-so, 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 so-and-so for assisting me in this case. So you try to dismantle the hierarchies which you see around you, and I assure you, you will be a happy person.
Brilliant.
Thank you so much, ma'am.
Abhishek.
Ma'am, Nitya ma'am, I have one question for you, and then we'll pick up questions from the audience because there are a lot of them from the audience as well. Nitya ma'am, my question to you is that in light of the discussion, the topic in discussion, what do you think is the most essential reform that you think is required in the procedural law or in our procedures? because there are changes in the substantive law, but what about the changes in the procedural law?
Well, the first question as a lawyer would be which procedural law? Criminal procedural law, there need to be changes, not necessarily because of women. The one clearly women-specific provision of the CRPC is, of course, Section 125, in which the upper limit has been removed. But procedure must be simplified and made more people-friendly. One other thing can be, which is generally my view, that in criminal procedure, just a few days ago I said this, and I'll quickly say it, that the way the magistracy functions, because that is really where most people have a brush with the law. Very few can enter the fancy, high-ceiling domes of the Supreme Court, and even maybe somewhat flatter domes of the Delhi High Court. So where the first brush that the citizenry, and therefore women, have with the law is where the magistrates' courts. And there, people from custody, people from custody come. I have seen in so many courts, their families, their wives come. That's the only place they come to see them. So making those places accessible and more human and habitable, and for the magistrate to engage with people who come from custody, explain the process to them, ensure that not everybody is driven to imprisonment. Some of the basic changes in criminal law, which have to do with human rights, would necessarily also impact the plight of women. Then, when women come from custody, I think that they have to have, and especially from police custody, there has to be a longer engagement by the magistrate. I don't know whether you should have a female magistrate or a male magistrate. There are various views on this. I'm not sure, but maybe it's easier for women to talk of the nature of treatment, because when a woman is produced from custody and she's brought before a magistrate, he barely looks at her and extends a remand or sends her to judicial custody. There is no engagement. So making these processes more people-friendly, ensuring that there is a checklist for the magistrate when people come from custody is one of the first procedural reforms that comes to my mind. Then it is for us to be cognizant, some very silly thing, like somebody came to serve something the other day on a friend of mine, and they found that she was at home and her husband was not. She said, they said, our law does not allow us to it doesn't count it as service if we serve it on women. So it is for us then to bring this to the notice, because many of these things, they have just crept into the law and they remain there. So every time you see something, whether in procedure or in practice, the point is to bring it up in whichever way we can. We can do it by way of publicizing it. We can do it by way of bringing it to the notice of the judiciary. We can bring it by way of a challenge. It would depend on the nature in which. But your question is too broad. But one thing that immediately comes to mind is strengthening the magistracy when it comes to, especially when it comes to criminal procedure and women from custody. That comes to mind. I'm sure there would be others.
Thank you, ma'am. So we have a question from the chat box, which we can take now. ABC's iPad, somebody who's using ABC's iPad. Is that you, Nandita, ma'am? So there's a question here. Wouldn't you say, if this is a question for Indira, ma'am, wouldn't you say that? Yeah, sorry, Nandita, ma'am, you can ask your question. Please, you're here.
No, you read it out. Sorry, I thought you were calling.
All right, ma'am. I was wanting to confirm if that's you. Wouldn't you, Indira, ma'am, this is the question for you. Wouldn't you say the judgment for ensuring designation has some merit-based marking is also a feminist judgment? Because it levels the playing field between people who are connected and people who only have their work to speak for them. What motivated you to challenge the designation rules?
Okay.
Good question.
I think it's an important question. Your first question was very important, namely, what are the little things you can do to make your environment a better place to live in. Now, I believe that you must act on your impulse. What the drive for what you do must come from within you. You must really want to do what you're doing. And that's also, the secret of success. So when it came to the issue of senior counsel, I saw so many of my friends and colleagues who I respected, who I admired, with whom I've had fabulous conversations, and some of whom I considered my equals, some of whom I considered better than me, who were not designated seniors. And for me, it took me back to my journey into feminism, which is dismantling hierarchy. And so the issue of how should seniors be designated, for me, became an issue of dismantling arbitrary hierarchies. Okay, the entire procedure was shrouded in secrecy. Nobody knew why a particular person was designated and another was not. All we could see in the public domain was that if you happen to be the son or daughter of a judge, you're more likely to be designated than anyone else. Now, I ask you, being a lawyer, how can you tolerate injustice around you? Okay. And remember, I was a designated senior. I was designated in the year 1986. And I realized, of course, that, a person who is seeking designation may not be able to raise this issue for fear of victimization. So that was another learning, a lesson for me. And as I proceeded further in life, when I faced victimization for having raised certain issues in the public domain about feminism, about sexual harassment at the workplace, I suffered very severe victimization. But I realized that, for even small successes to come your way, there has to be collective speaking out. And I think that, if I'm not mistaken, all of you have got together precisely in the interest of collectivity. And, you said I founded an organization called the Lawyers Collective. Now, we can debate endlessly what collectives means, but the fact is that you need to be able to convince a community around you that the issue you're raising is the right issue. And I was speaking to a lot of my colleagues at the bar, and many of them felt that this was an issue waiting to happen. So that answers the question, what motivated me.
बस हो जाएगा वो आ रहे नीचे
Can we have the interloper removed? Okay. Anyway,
Nitya ma'am's video. Sorry.
Okay, then it's okay. Nitya, certainly you must have your say on all this too. I thought some of those fellows who said feminism is cancer were back on the program, and I got really nervous. You see, even people like me at my ripe old age of 80.
I'm very upset that you confused me with one of those rooms.
See, Nitya.
Hindu, you have a lot to answer for.
Okay, so here's my answer. See, Nitya, at the ripe old age of 80, I'm still a nervous person, I hear, it's like being afraid of mice and cockroaches, So where is your sudden bravado? Where does it disappear when I hear a small little noise? It just disappears. But anyway, so I think I've answered Nandita's question as to what motivated me to take this to court. I am a little disappointed. But Nandita, there's a companion question to that, and that is, why did I discard my senior gown? Now, let me just quickly answer that question. It is because one day, while arguing in court, I told the judge that outward symbols of discrimination must be discarded. And differences in gown are outward symbols of discrimination. It's like a caste mark. And the minute I uttered those words, I came out of the courtroom, I discarded my senior gown, and I must tell you that some prominent women when members of the GAR came and gifted me a junior gown, which I continue to wear to this day. So Nitya.
Next question, and then I'll have
Thank you,
to go
ma'am.
because I'm needed in the hospital. So just if you have a quick question for me, ask, and then I'll have to go. I'm sorry.
Nitya, ma'am, thank you so much for the kind
Yeah,
consideration.
Abhishri, if you'll permit me, I had one question, Nitya ma'am, to ask you, and I think a lot of us have been discussing it, as Indira ma'am said, that we've read in LiveLaw and Bar and Bench that Arnab Chaudhary, Arnab Goswami, who's been detained by Mumbai police, has filed a habeas corpus petition saying that his remand order is illegal. And this was a petition that you had for the first time as a lawyer filed for your client Gautam Naulakha and obtained an order from the Delhi High Court. So do you think that it vindicates the constitutional point that remand is just not a mechanical thing? And would you like to make some remarks on this? And ma'am, after you, even Indira ma'am, what are her views on this? And then I leave it to the moderators if they want to close.
Nandita, I don't need Arnab Goswami to vindicate that position. There are Supreme Court judgments, even before Justice Muralidhar's judgment, that a remand is a judicial order, but if it is made without application of mind, then it's a non-est order. And ultimately, a habeas corpus petition concerns liberty and due process of law. So an invalid remand order is not due process of law. There are 3 judgments which were, in fact, are quoted in Justice Muralidhar's judgment. And that question has been left open by that judgment. The questions of law which were raised by the state were kept open by the Supreme Court. But independently of Justice Muralidhar's judgment, there are Supreme Court judgments. There is that Mohammad Tahir Hussain, and the names don't immediately come to me. So in our case, for instance, the magistrate had remanded without looking at the case diary. Some documents were brought in Marathi to this judge, who there's nothing to show that he knew any Marathi. He was not told why this custody was needed, and he signed on that transit remand. So that principle of law remains. And whether Arnab Goswami's remand order suffers from those lacuna is a different matter with the Bombay High Court. We'll see. But the principle of law is not that merely because there's a judicial remand, there can be no habeas corpus. That has never been the position in law, and it is not still. That I really hope I don't have to depend on Arnab Goswami to vindicate any position of mine.
Thank you, Nitya ma'am.
May I leave? I'm sorry, I'm being called in at the hospital. So can I just go? Thank you for accommodating this, this rambling,
certainly
ramshackle way in which I have addressed your webinar. Thank you for accommodating me.
Thanks.
Goodbye, Indu. Thanks.
Goodbye, ma'am.
Bye, Nitya. Bye. So, Nandita, do you want me to just make a quick comment on that?
Yes, please.
See, first and foremost, I don't like, whataboutery. So one of the first things that I put on record for myself was the question is, does one have to arrest everyone simply because an FIR has been lodged? Okay. And I would go one step back from your question of remand. For me, the real question is, was there a need for arrest at all? Okay. And there I have gone on record to say that in a case like this, which began in 2018, and where there was a closure report, what should have been done was that the person should have been given a summons under Section 91 and asked to come and make a statement. Where was the need for an arrest? Do we have an understanding of what is the meaning of the right against self-incrimination? And you, being a public prosecutor, must enlighten me on this. I have always wondered, what is the purpose of custodial interrogation? Is it to torture the person to get an answer on the record? Because to an outsider like me, not being a public prosecutor, it appears to be so. So why have we forgotten Article 20, Sub-Article 3 of the Constitution of India, which says no person can be compelled to be a witness against himself or herself? So we need an answer to the question, why was this person arrested in the first place at all? There was no flight risk. No one says that Arnab Goswami is going to abandon his The Nation Wants to Know program and disappear to some other country. So why was he arrested? For me, that's the critical question. Now, on the second question of whether an order of remand is non-est, you can have two views on that issue. And it is going to turn on the facts of the case. So one view is that under all circumstances, a remand order has to be challenged by due process of law. Nobody says it can't be challenged, but by due process of law. And the other is the point of view that Nitya projected, namely that a habeas corpus will lie. Now, in a manner of speaking, it's of course a technical argument, okay? But in today's day and context, what is happening is, now let me, Nandita, I'd like to end, this is very important for your viewers on this program to understand. I filed a petition on behalf of Varavara Rao in the Supreme Court of India under Article 32 while he was in detention, lawful detention. And Justice Lalit told me, Madam, can you argue that he's not in lawful detention? I said, I cannot argue that he's not in lawful detention. But my case before you is that prisoners, simply by virtue of lawful detention, do not lose their fundamental rights. And look what you've done to this human being. You've reduced this man to skin and bone. He can't keep body and soul together. I quoted from a judgment of Justice Krishna Iyer, which says, even behind prison bars, you have to keep body and soul together. So that I did invoke, I didn't call it a habeas corpus petition, but I said, you set this man at liberty because his conditions of detention have become intolerable. Now, I think I'd like to stop over here. And I think it's a very, very important argument that I've made for a person who deserves to be at liberty at the age of 81. He's bedridden. His urinary catheter hasn't been changed for 40 days. When his family met him, he was lying in a pool of urine. Where is your fundamental right to dignity? And are we saying that all these rights are negotiated away during a period of incarceration? It cannot be so. So I think it's a field of developing jurisprudence. And I think lawyers like us should use every single argument available to us. We can use an argument that the remand order is non-est, but you may or may not succeed on that. We can file a bail application, we can file a quashing petition, and we can file petitions under Article 32 or 226. I don't see why one has to be used to the exclusion of the other.
Thank you, ma'am. I think we'll have two more questions quickly, if you permit us, because there's so many questions in the chat box. Allowed?
Yeah, you have to decide when you want to terminate your program.
Right, ma'am. So quickly, Abhishri, can you ask? There's this one question from Bar and Bench.
Yes, we have one question from Rintu Mariam. So it's an interesting question, ma'am, for you. How do we foster change in the mindset of judges, speaking in terms of gender sensitization while dealing with crimes against gender minorities?
I'm sorry, but I don't like the use of the word mindset, okay? We are not concerned with the mind of the person. We are concerned with the overt actions of people, okay? The law criminalizes overt actions, and it's impossible. We have been trying to change mindsets for generations, but mindsets change when they change. So I would prefer to focus on the do's and don'ts of gender justice. And what I would like to see is binding guidelines issued by the Supreme Court of India, which tell judges what they should say in a judgment and what they should not say in a judgment when it comes to the issue of gender justice. So language matters. This is what I'm trying to tell you. Instead of using an expression like, oh, she was ravished, you need to say she was sexually abused, okay? So I think there are two issues here. One is help judges to change their language. And it might interest you to know, it might interest your viewers to know that we at the Lawyers Collective are currently working on what we call a gender glossary, which will be like the alternative Black's Law Dictionary or the alternative Iyer Dictionary, or call it what you like, where we are going to put all these terms. And we would certainly like to crowdsource these terms. So any of you are welcome to send in for this dictionary. It's a crowdsourced dictionary. It's going to be a work in progress, where you can send us expressions that you encountered in judgments which should never have been there because they betray a patriarchal orientation. And the second thing I'd like to see is that these guidelines should be binding guidelines. So then mindsets will change. So I believe that the process of changing mindsets has to begin with binding guidelines. After all, it is the duty of the Supreme Court. You know, all constitutional courts in the world issue practice directions. And ours is the only court which does not issue practice directions. And these, you see, you have the Supreme Court has said that you cannot give a judgment that a rapist should marry the woman he raped, because that would be adding insult to injury. And today I read a report in LiveLaw where the Madras High Court has said, when this girl turns 18, the rapist should marry her. Now, what do you do? What do you do? Isn't it a case where the Supreme Court should haul up this particular judge and make them accountable? So according to me, accountability and binding, but the time has come for accountability of judges and binding guidelines.
So there's one quick question from Mosmi about this, and she wants to know it from you. If you could reflect on gender-inclusive language in the court of law, in Constitution and in preamble to the Constitution, what is your say on word fraternity in our preamble, as mostly feminists say that this word is anti-women? If there is brotherhood, there should be a sisterhood. Just want to hear you, Indira ma'am. Thank you.
Well, if I was left to redraft the Constitution, I probably would say that. But I'm going to leave you with one little story which illustrates everything. There was a judge of the Constitutional Court of the South Africa who was a very close friend of mine and of Mr. Grover's as well. And his name was Edwin Cameron. Now, he was being considered for appointment to the Supreme Court from the Constitutional Court. And he wrote to the appointing authority to say, before you appoint me, I would like you to know that I have HIV. I would also like you to know that I'm gay. Now, having made this disclosure, you decide whether you want to appoint me or not. And he was appointed. So the thing is also, of course, language matters, but more important than language is what we do in our daily actions. The decisions we take are even more important than language. We can overcome hurdles of language, but we can't overcome hurdles of prejudice. We have to consciously work to overcome hurdles of prejudice and discrimination. So, and I know, all of you have read about the case of a young lawyer who's been considered for appointment as a judge of the High Court, and he's gone on record to say, I know that I'm not being appointed because I'm gay. This is what we need to change. Here is where we need to come in with our collective strength to say, why not? If the person is otherwise meritorious, why are they not being appointed? So if you want to change the preamble, change it to include the entire LGBT community, transgender, which will go beyond sisterhood. I hope I've answered your question as best I can.
Ma'am, before we close the session for today, I just have one question for you, ma'am, in light of what you'd actually mentioned in your speech. Ma'am, in terms of what you had pointed out regarding untouchability and menstruation, obviously, even today, it's a very big social reform that has to come even in today's generation. What, in your experience, was the best way, since you personally dealt with it, what in your experience was the best way to deal with such situations internally, within a family or within office spaces or even otherwise?
Okay, it's very difficult to deal with it within a family. It's easier to deal with it in public spaces. I would like to tell you that the first woman who entered Shabrimala was a Dalit. Her name was Bindu. And it happened on the 1st of January, but on the 31st of December, women in Kerala constructed a women's wall which went from the commencement of Kerala to the tip of Kerala. And of course, I have no doubt in my mind that this is what gave her the courage and the strength to climb that hill that she climbed along with another Hindu woman whose name is Kanaka Durga. Now, Kanaka Durga suffered huge consequences within her family. She's in touch with me till today. You know, her husband divorced her. Her mother-in-law said, "How dare you climb the mountain, a hill, and go to Shabrimala?" These are some of the, hurdles that women have faced within families. The last thing that I'd like to tell you is that in Nepal, for example, they have passed a law. They have passed a criminal law criminalizing the putting out of women during the period of menstruation. Now, I don't know enough about their society to tell you whether it has worked or it has not worked. And in a manner of speaking, I agree with Nitya that more and more criminal lawyers may not necessarily get us to our destination. But no, laws do set norms, okay? Even if they're not implemented, they give society a message that this kind of behavior is not acceptable. So I guess at the end of the day, the only thing I have to say to you is we need to work together to end this. Support your mother if she's in that situation. I couldn't do it. I was too young to understand what was happening to her. But today, I would support any woman who is facing this kind of discrimination.
Thank you, Indira. So to sum up over and all, a lot of questions still there in the chat box, but I think that the time, we have to keep the time in mind. So I'm just summing up a few questions where there's this 2 questions to join, which says that what, in your opinion, are the integral changes and the reforms that are required in order to make Constitution a direct answer to demands for equality?
Ozia, that will require a separate webinar.
Right,
I'm not able to answer that
so
question.
another quick one is talking about tracing a path from invisible to being invincible. What is the message that you would like to give the lawyers today to fulfill their own journey?
That I'm happy to answer. I'm happy to answer that. Let me tell you that it's a great advantage to be invisible. Okay. I'll tell you why it's a great advantage to be invisible. It's a very powerful position because you can observe without being observed yourself. Okay. I can tell you that very often when I'm inside a courtroom, people behave towards me as if I'm invisible. Now, I have 2 ways of dealing with it. I could take offense and push my way around and say, here I am, make space for me. Or I could quietly sit there, and I choose to do that and take a look at every one of their expressions, every one of their mannerisms. And when I get my opportunity to address the court, I verbalize every one of them. So I move from the invisible to the visible in the courtroom. And I can tell you this happens to me till today. When I enter a courtroom at the age of 80 years, because I refuse to conform to male networks, I am invisible. You can only be visible. And I don't want to be visible in that manner if you're part of a very powerful male network, and if you're happy to be patronized by that network. I'm not willing to be patronized. I choose to be the person I am, and I'm a very happy person.
Great, ma'am. So with that, we go. I mean, I think you've said it so beautifully that it reminds me of a very beautiful couplet which says, सलासल कब तक रोक सकेंगे, मेरी कुव्वतें आया हो चुकी हैं, मदारिस कब तक टोक सकेंगे, मेरी जुम्बिशें रवां हो चुकी हैं, निज़ाम पिदारी से बगावत है तहरीक मेरी, कमज़ोर कमज़र्फ नहीं है तजवीज मेरी, मैं तुम्हारे वजारत खानों का रुख भी कर चुकी हूँ, अब ये ख्याल छोड़ दो कि आराइश है तख्लीक मेरी. I saw in the chat box to explain my couplets. I'll just quickly tell what it means. How long shackles hold me back, My powers have long been revealed. How long will madrasas rebuke me? My crusade has long been afoot. My mutiny is against this patriarchy, and my schemes are neither weak nor credulous or foolish. I have made my way to the houses of power from where you oppress me. It is time that you know that my creation was not for the ornamentation of your world. उसूलों पर जहां आज आए वहां टकराना जरूरी है उसूलों पर जहां आज आए वहां टकराना जरूरी है जो जिंदा हो तो फिर जिंदा नजर आना जरूरी है Thank you.
Beautiful. Thank you. Thank you, all of you, for inviting me. It's an
Ma'am,
honor.
that's you. The couplet is you, and we are all inspired.
Thank you for inviting me. It was a pleasure, absolute pleasure.
This is dedicated to you, ma'am.
Thank you so much, Fazia. You're such a doll.
Right. I would now request Kritika. This is so wonderful, ma'am. We just want to hear you, and just keep going on and on. But keeping the time in mind, again, as I said, there are so many people who joined us today from all over the world. I see a lot of my friends from the UK, from USA, Canada. A lot of people who joined us today from India and everywhere. So I would just now quickly request, thank you, Abhishri. She's worked very, very hard. Before I, request Kritika to say the word of thanks, I would say that I would want to thank Nandita ma'am, Rinalini, Sunita, Abhishri especially, my co-moderator, who's worked very, very hard to put this together.
Ma'am, it was a pleasure working with you as well.
Great.
Over to you, Kritika.
Just request Kritika to say the vote of thanks.
Thank you so much, ma'am. On behalf of the Delhi High Court Women Lawyers Forum, I would like to thank Indira ma'am and Nitya ma'am for sharing their wisdom and their stories. Ma'am, we are grateful from the bottom of our heart. Thank you to our fabulous moderator, Miriam ma'am and Abhishri. It was a beautiful session. A big vote of thanks to Nandita ma'am, Sunita ma'am, Mrinalini ma'am, and Soumya ma'am for all this behind the scenes action. Thank you for your effort. Thank you to LiveLaw for covering our session. This is a session which needs to go far and wide. Thank you so much. The Delhi High Court Women Lawyers Forum is also pleased to announce the next session of the virtual canteen, which will take place on the 20th of this month with Justice Lokur, Ms. Varisha Fasad, and Ms. Shalini Gera, with Tara Narulaji and Ms. Sojanya as the moderators on defending liberties and representing outliers. Please join us on the 20th, and thank you for joining in today. Thank you so much.
I would also quickly want to thank LiveLaw, our media partner, and Soumya, of course, for putting out the tweets and everywhere on the social media. So it is made very important for all the viewers to join the live streaming while it was spanned. So this is how important the law and media becomes together. Thank you. Thank you very much.